Hey, yo, folks, it is Friday, and we have a bunch of stuff to get through with the Delphi case. We have here's the Richard Allen's defense, their memorandum in response to Indiana's. Well, it is 24 pages. 24 pages. Hello, Mr. Jingles. Hello. Hello. And then we also have media is getting really, really tired of not getting exhibits that are, as of the sentencing, public information. So they are getting fed up. So because Judge Gold denies it with, it's too vague, it's too this. Oh, the latest one? Oh, they put up an itemized list. And yeah, so we will go through that too. I have no idea how long we will go on. I do know I have invited a few people who one isn't available until 7 p.m., I believe, and that is in 4 hours. And then two who may or may not show up. But we will just have to wait and see if I get some guests on, or if Mr. Jingles, excuse me, hello, hello, we good, we good. Hmm? Yes, yeah. You will get treats. You will get treats. Now, since it's Friday, I am feeling quite healthy. I got myself a treat. This is Neutzeller Schwarzbier. This is a good one. This is a good one. So now, the name might give it up. Schwarzbier, yeah, black beer. So, and then you let it rest for a bit until you pour it up. Hello, folks. Hello, folks. Good to have you here. Good to have you here. I saw this curative instruction became a new member. Thank you so much. That is so nice of you. Welcome to the Viking crew. And now we have access to members-only content on YouTube. You have access to emojis in the chat, and also if you go to the community section on my YouTube, you will find a link to my Discord. Yeah. And so very thank you, very big thank you, and hello to Amica Fan, Mandy Galasso, Amy Warrior, Denise Sells, Heyo, Kayla, California, Erin, It's a New Day, Divans Moore, Gwendolyn, Elena, hello, Christine Fortunato, hello, Fun Size, and oh, look at that, Erin became a member too. Thank you so much. That is so nice of you. That is so nice. I need to have a banner up. Hold on. Dun, dun, dun. Dun, dun, dun. There. Thank you, thank you, thank you. And if anybody else is contemplating it, it's $3 a month. It is $3 a month. Ooh. Oh. So this is ein Schwarzbier. Cheers. All right. George Jessica is here and Salty C is here. And oh, look at that. Salty C. All right. We have a swarm of new members today. Thank you so much. Now, Salty C and Erin, yeah, access to my members only content on YouTube. Your own emojis on YouTube, and access to my Discord. And once in a while, I'll ask only members some questions about what's going on, anything, you want me to cover, and stuff like that. So we have good interactions, me and the members. Very good interactions. Hello, Marianne, also. Fondy and all right. Now, what shall we do first? I think we are going to do the Richard Allen verified reply first, and because once we get into the amended Twist Media amended motion regarding the evidence, the list is really itemized, and it might be a bit of a trigger. Now it's only in text, so how do I donate membership? That should be, if you go on the bottom of the chat, there should be a dollar sign something, and then you have membership gifting there. That is how you do it. But again, as I always say, and this is why I'm such a bad grifter, if you never choose between me and something you need. Never. If you, in this somewhat turbulent economy we have right now, I'm fine, folks. I'm fine. But if you have the means and you want to, I will not stop you. Okay. Yeah. If you're on an iPhone, you have to go out of the app and into your web browser or something of the sort. Ask somebody in the chat. I have no idea. I am an avid Android user. Let's see here. So, hello, Rebecca. And hello, you over at Rumble. Yes, I'm streaming at Rumble as well. And hello, you folks over at X. Beautiful kid. Yes, this is Mr. Jingles. Don't have an only cats moment on live stream, please, Mr. Jingles. Yeah, I know you clean yourself. You like cleaning yourself. Yeah. Oh. Yep. Well, it's more than one type of show here today. Now, for anybody who wonders, this is Mr. Jingles. Mr. Jingles runs the show. He runs the channel. Everything I do here is about making him comfortable, getting him snacks and toys and stuff. For fuck's sake. You're very thorough today, Mr. Jingles. Oh, yeah. My apology. We have Mr. Jingles need to take care of things before we go into the reading of this motion or memorandum. Are you done anytime? Hello. Yeah. All right. Now it's moved on. Now you just jealous you can't do that. Of course. Yeah. All right, folks. Let's get to work here. Let's see here. Can I make it bigger there? Can I make it a little bit bigger? All right. State of Indiana, County of Carroll versus Richard Allen. Richard Allen's verified reply memorandum to State of Indiana's response to preserve and produce and request for sanctions. Yeah. Now, the State of Indiana opposes preservation of evidence. They opposes the production of. Yeah, it is insanely stupid. They oppose the production of evidence they refuse to give the defense before trial. Of course they do, because why not? All right. Comes now Richard Allen by counsel and files this reply to the State of Indiana's February 28th, 2025 response to Allen's motion to preserve and produce and also request sanctions for the state's violation of Carroll County local rules concerning exculpatory evidence. In support of said motion, Allen states the following. Yeah, I made a video not that long ago about the Richie letters, which conveniently was in the possession of the prosecution for quite some time and didn't tell the defense. That is textbook Brady violation. Textbook. The prosecution's response brief provided proof that the state of Indiana failed to turn exculpatory evidence over to the defense. In his response, the prosecutor glosses over the fact that he was in possession of letters that he failed to turn over to the defense before trial. Even though, in a February 30th, 2025 email, he denied possession of such letters. Yeah, McLeland, you absolute twat. You lied to the court. You lied to the defense, and you lied in a sworn. I mean, these kind of maybe not in an email, but it's still statements. So it's not sworn under the penalty of perjury, but still something that easily controllable. And McLeland still lied. McLeland also has no explanation as to why a letter from Davis from October 15th, 2024 is missing and can't be found. Instead, the prosecution spends the majority of his response denigrating defense counsel. And this here. Prosecutor McLeland is not the arbiter of exculpatory evidence or whether he has an obligation to turn it over. The law is the arbiter. Quote unquote, exculpatory evidence is defined as evidence tending to establish a criminal defendant's innocence. State versus Durrett. Carroll County Local Rule 18b2 also requires McLeland to turn over exculpatory evidence. Based upon his February 28th, 2025 filing, we now know that the state of Indiana had certain letters in its possession in October of 2024, but failed to turn those letters over to the defense until February 28th, 2025. The prosecution only produced those letters after the defense sought those letters, being forced to file a motion to produced those letters after the prosecution failed to admit being in possession of these letters. Yeah, that was Ricky Davis calling out from prison. Hey, I sent them letters, 6 of them, before trial. Before trial. And the prosecution didn't care. Now, we know that Judge Gull doesn't care as well. But this is important for the appeal. Court of Public Opinion. Hey, Nick Starrow. Hello, Court of Public Opinion. Hello, good to have you here. Ms. F. Hey, hey, yo. I will try to keep track of your chats here. I will do my best effort here. But once I'm into a document and reading it, you have seen me do this before. I get hyper-focused on that. So if you have a question of sorts and you see, oh, he didn't see it, put big question marks, the big red ones, before and after. That way I might catch it, or just repeat it until I see it. Okay. Okay, let's continue. This behavior of the state is consistent with the pattern of behavior that has greatly impacted the defense and Richard Allen's constitutional rights throughout the entirety of this case, and will be recounted later in this memorandum. A pattern of withholding exculpatory evidence may lead to a reversal and new trial. Prove it, we state. And it says here, from that case, this case illustrates what happens when the state engages in a pattern of withholding exculpatory and material evidence from a defendant prior to trial. In Pruitt, the Court of Appeals reversed the conviction when, soon after the conviction, the defense counsel learned of evidence that the prosecutor failed to turn over to the defense prior to trial. Yeah, it should be that easy. If something has been in the possession of the prosecution and they didn't turn it over, and the defense finds out after the trial that they didn't, that should be just a quick run up to the appeals court. Hey, the fuckers did this. And the appeals court's reply should be, what? The fuckers did that? You get a new trial. Yes, those question marks and stuff. So that should be all that's needed. But we know that Judge Gull will deny this. It will take time and everything. We already know this, but this is still important to get into the filing system, on the record. Defense theory. At Allen's trial, the defense indicated that the evidence supported that on February 13th, 2017, the victims were abducted, taken somewhere else, perhaps in a vehicle, and then during the early morning hours of February 14th, were ultimately transported to the location where they were found. Further, the defense's theory was that evidence strongly supported that multiple people were involved in the abduction and ending of the victims. The defense theories were detailed in the defense opening statement and throughout trial in offers to prove from August 1st, 2024. State's theory. The state's theory was that in some order the following events occurred. The killer, acting alone, after running or briskly walking across the bridge to catch up to the girls, since he was not seen in the 207 photograph anywhere on the bridge, was seen on video walking casually and not panting like a 45-year-old man who had run across the bridge. Then abducted the 2 victims, slid down a steep hill with those victims, then in a panic after observing a van, corralled those victims across an active creek while holding a gun, and then both victims somehow were undressed, but the younger victim was later redressed in the pants and underwear and sweatshirt of the older victim, and the lone panic killer murdered one victim and then murdered the other victim without anyone hearing any screams, in spite of sound traveling very well throughout that area, all the way to the bridge. Then the lone panic killer moved the older victim from one area to another area next to a tree without any drag marks, indicating that he carried her from one place to another. All that activity, according to the state's theory, occurred in a 19-minute time frame between 2:13 p.m. and 2:32 p.m., when the older victim's phone stopped moving, having been placed under a shoe under the younger victim's body. After the murders, the state's theory was that this panicked killer then took time to place sticks on top of the victims' bodies, in particular patterns, as depicted in photos admitted at trial, and then, in spite of his panic, hung around the crime scene for over an hour before exiting the crime scene northward near a cemetery, before this panic killer chose to walk westbound towards his vehicle on 300 North in a bloody outfit, knowing that he would be in full view of any vehicles traveling that road, after having killed the victims an hour and a half earlier. The state's theory was not that multiple men or women were involved in the crimes, but one man alone committed all these acts and did so on the afternoon of February 13th, 2017, sorry. Yeah. Condensed that way, does it? I mean, that in itself. I don't know. Nobody knows what exactly was said during the closing arguments and anything, but this condensed version makes it sound. Come on. And then they go into the Richie Davis letters, provide exculpatory information that supports the defense theory and negates the state's theory, and also provides other information that the defense could have utilized for trial or to support its request for third-party suspect evidence to be admitted into evidence. Yeah, Judge Gold denied them, as you know, third-party culprit defense, because she claimed there were no nexus. Now, we all know that's a lie. We do. But in Judge Gold's eyes, not even a confession, not even two confessions are enough of a nexus, even though that is the actual definition in Indiana rules. In Davis' letters that the state of Indiana did not turn over to the defense before or during trial, Ricky Davis stated that Keegan Klein, a key suspect in the case, confessed to the murders. A key suspect confessing to the murders is exculpatory evidence, as it tends to establish a criminal defendant's innocence. Fucking da! Ta-da, I meant. ID, at a minimum, Carroll County local rule required McLeland to immediately turn those letters over to the defense, even if he believed that the letters did not need to be turned over, because Davis claimed that Richard Allen was involved in the crimes alongside Klein and Keegan. Yeah, that's Ricky Davis' theory. He thought that Richard Allen was the third guy. But yeah, but if something speaks against the state's theory, they have to turn it over, including but not limited to Ricky Davis believing that there were three people and Richard Allen was the third person. When police or prosecutors conceal a significant exculpatory or impeaching material in the state's possession, it is ordinarily incumbent to the state to set the record straight. So, the question is not whether the defendant would more likely than not have received a different verdict with the evidence, but rather, in its absence, he received a fair trial understood as a verdict worthy of confidence. Kyles v. Whitley, U.S. Supreme Court, 1995. The jury in Richard Allen's case was out for nearly 4 days, a very lengthy deliberation period. I agree. In this case, Keegan, as it seems, the jury more or less said, if not Rick Allen, who else? Now, that in itself should be a reasonable doubt, but yeah, you never know what the jury says. In this case, Keegan Klein's confession to the murders and also Klein's claim that Ron Logan was involved are clearly exculpatory statements. These were the two most likely suspects during the investigation. Those two and a few more, I must add. If it could be shown that they knew each other, that would be a significant fact for the court to consider when determining matters of the third-party suspect defense, and also for a jury to consider. Yeah, Keegan Kline, Ron Logan. Folks, Delphi, Indiana is very, very tiny town. 3,000 people. 2 people with an interest in minor girls. Chances are they knew each other, but the prosecution said, let's not hand it over. The fact that Kline also implicated Allen would not have been of a concern of the defense, as the defense knows that Allen had no linkage to either Kline or Logan, and also because the evidence supported that Allen was with his wife the night of February 13th and morning of February 14th, when Kline was claiming Allen was with Logan and Kline committing the crimes. Yeah. So that's out the window. Had the defense known of the information contained in the Ricky Davis letters, it would have renewed its motion for third-party suspect defense regarding Kline and Logan and would have further investigated these claims. Perhaps the defense would have sought a continuance to investigate the ties between Logan and Kline. The defense could have argued that Keegan Kline knew details of the crime that no one else knew, and furthermore that he, Kline, was protecting an unknown third party by claiming that Allen was the third party after Allen's arrest. The defense could do none of that, as well as any other number of legal, strategic, procedural maneuvering if the defense, was in the dark about the contents in the letters while the prosecution was fully aware of that information. Hi, World's End. No notice as always. Yeah, I know. YouTube have some kind of shadow ban on my channel, and I have a quarter, maybe a third of my usual viewers, but I keep putting stuff out, and sooner or later I will break through that. I mean, you've seen it with RC Overlord. You saw it with Kurt on civil law. Sometimes YouTube just decides, hey, let's make these guys work way too hard. That seems to be a standard issue. Fondian got a notice. That's nice. And Stringer Bell got a notice. Okay. Maybe things is about to turn around. The details that Kline provided to Davis add to the exculpatory value of those letters. On page 4 of one of the letters, Davis claims that Klein detailed that the girls' bodies were moved 3 times and that they were not killed where they were found, and furthermore that their bodies were staged. These are facts consistent with the defense theory and facts that oppose the state's theory. Furthermore, in the letter, Davis claims that Keegan Klein detailed how the killers got nervous and left town in their own cars, with at least one of them going to Lafayette to get rid of evidence. It is known that Ron Logan went to Lafayette at some point in time to purchase exotic fish after having asked a relative to assist him. Ron Logan in creating an alibi. Yeah, for you who don't know, Ron Logan, despite, according to the prosecution, Ron Logan had nothing to do with this. Well, if he didn't, why did he create an alibi for the time frame that is important in this case? And he did that before anybody knew when the girls were killed. He created an alibi for a very narrow time frame, which is in the afternoon of February 13th, 2017. These are all facts that Ricky Davis would not know, but that the killer would know. All of those facts tend to establish Richard Allen's innocence. In the second letter, Davis claims that back in 2018, he reported that the victims' throats were sliced. This is something only the killer would know, especially when the details of the murders were not known at the time. Check in. Mo went through this on her channel, on my channel, Mo in the Deep End, up until Richard Allen more or less was. Everybody thought that, it was a gun involved. No, it was never a gun. He also stated that he reported that the girls were hidden in a barn and also driven around at some point in time. This is consistent with the defense theory that the girls were driven in a car at some point and held somewhere until the search parties had left the area, and inconsistent with the prosecution's theory. On page 3 of that letter, Ricky recorded that Keegan Klein told him that the scene was staged, and furthermore mentioned that the girls could not be moved because the search parties were everywhere throughout the night at that time, meaning that the girls were moved to the place they were found only after the search party left the area. This is just as the defense claimed, thereby supporting the defense theory and negating the state's theory. In his February 12, 2025 interview at Newcastle Prison, Ricky Davis provided further detail that Davis, claimed believe that he also provided to the prosecution concerning details that Keegan Klein stated to Davis. In that interview, for example, Ricky Davis claimed that Keegan Klein stated that the girls were handcuffed to each other. After the meeting, defense counsel Auger, Baldwin, and investigator Matt Hoffman viewed the crime scene and autopsy photos to determine whether there were any indicators on the victim's wrists that could support this new information that the victims were handcuffed to one another. The admittedly non-expert eyeballs of the attorneys and investigators observed straight lines on the left hand of the wrists of both girls, which, if true, could indicate that one victim walked immediately behind the other with each of their left hands handcuffed to each other so that they could not easily run away. If the defense had received these letters, it could have learned these facts from Davis during a deposition, if they weren't contained in the letters, and then had experts view the same photos to determine whether the photos were indicative of the girls being handcuffed. Yeah. Curious Contrarian. Love you, Nick. Love you too. Just remember, chat. Richard did the munching on doo-doo. And you hope he's getting the Darren Brooks treatment. Okay. Curious Contrarian. Reveal yourself. Name, address, everything. Because what you do is promoting rape, which makes you, in my eyes, a rapist. Go fuck yourself. You criminal cunt. Go fuck yourselves all the way to fucking hell. You absolute retard motherfucker. You sick motherfucker. Promoting rape. What? I hope by everything in God's green earth that you will never experience what you hope others will. And Curious Contrarian, you paid $5 to get my foot in your ass right out. I don't need perverts like that on my channel. Okay, can we continue now without being interrupted by evil perverts? Can we? Okay. Yeah. Well, thanks for the $5, but yeah, I'll probably get demonetized. But yeah, nothing new on that front. All right, let's continue. I see you, Beardew. Nah, that was not what the pervert talked about, in my opinion. Had the defense known of the Keegan-Klein statements to Ricky Davis, it could have brought both Keegan-Klein and Ricky Davis in for a deposition after hours or during the weekend while the trial was occurring. These depositions could have revealed additional information, including whether at some point in time Keegan-Klein finally admitted that Richard Allen had nothing to do with the crimes, as Ricky Davis stated to counsel during a jail interview on February 12, 2025, and also to show that Keegan-Klein's claim about the activities of the third person involved with him and Logan was inconsistent with Richard Allen's whereabouts the night of February 13th and morning of February 14th. The defense likely would have called upon Kathy Allen to show that Richard Allen was home during that time frame and not with Logan and Keegan-Klein. Yeah, and also, where was his phone? Were they close to each other? GPS, anything. Additional. So it's the same person. Fuck off. So he just, Curious Contrarian, just changed his account and kept it going. Go fuck yourself. Absolutely go fuck yourself. Now, if you want to keep going, account and keep giving me money, go ahead. I will punt you to hell every time, and you will pay for it. So go take your pervert ass away from my channel. And for the first time in a very long time, if this asshole has a channel, you do not have permission to do anything with my content. Not a single thing. Usually, unless I say otherwise, I have a Creative Commons license. In that, assholes, no, not for you. Not for you. You are not allowed to use anything, not even a second, of what I produce here. All right, let's continue here. Additionally, the defense could have asked the Department of Corrections to provide video from the very part where Ricky Davis and Keegan Klein were housed to determine whether Klein and Davis were frequently talking with each other, as Klein has apparently stated in State's Exhibit 4 that Klein has only talked to Davis maybe 2 times. If the video shows that David and Klein talked to each other well beyond 2 times, then it could be determined that Klein was lying. Whereas, if the video shows that Davis only talked to Klein 2 times, then it would show that Davis was lying. So either one of them was lying. Well, had you had everything over, McLeland, then that could have been determined. Now, just by the actions of McLeland tells me he knows he's lying. He doesn't want these things to be revealed. Welcome to my show. This is a commentary channel, and I am not afraid of words. Hi, Erica. Good to see you. Good to see you. And hello, Lacon, and everybody else. Let's continue here. Things will not improve with alcohol. My language, the words I use at one point or each other, I will try to behave myself. I really try to. But and I do have patience. I promise you, I do have. What I don't have is fucks to give with retards. I really, really don't. When I say retards, I don't mean people who are medically have deficiencies. I'm talking about the people who choose to be. I have zero patience. I have zero fucks to give with those people. All right, let's continue here. Either way, the defense had a right to those letters to conduct its own investigation concerning the veracity of the contents of those letters. McLeland claimed that he did not turn over the Davis letters because he, McLeland, made his own determination that the letters were not in fact exculpatory, and denied Allen and his attorneys the opportunity to conduct his own investigation from the information contained in those letters, and to determine what to do, if anything, concerning the contents of those letters. In his February 28th, 2025 response, McLeland makes much noise about Attorney Baldwin attempting to put into the public domain information through the filing before verifying that information. It should be noted that Attorney Baldwin first attempted to work the matter out with McLeland via email before filing his motion. On February 12th, oh, Jesus Christ, are all the self-proclaimed retards out here? No, Kenny Powers. I get triggered. This claim here is clearly by somebody who is very, very close to medicating itself to being a retard. Claiming that I do not get triggered over the victims. You can't. You absolute cunt. You absolute cunt. I get triggered over fucked up investigators, corrupt prosecutors, taking bad evidence to court, and then have absolute fucktwat morons disturbing my show and making lies. Here's the thing, folks. What this cunt probably will do is he will retract the payment. I've seen it happen before. So it's just, oh, pay attention to me. Pay attention to me. Pay attention. Yeah. So he will put out super chats, then do a retraction on his card, and then sometime in the future make new accounts. That is so pathetic. That is so pathetic. So, but maybe it won't get retracted, and the allowance you get from the man your mother claim is your dad will run out. Or he's just going to let's report his channel. Look at his words. Look at his words. Here's the thing. Whatever you call yourself, once you do these payments, you're traceable. You're traceable. You know what I do for a living? I trace people. All right. In his February 28th, 2025 response, McClellan makes much noise about Attorney Baldwin attempting to put into the public domain information through the filing before verifying that information. I already read that. On February 12th, 2025, Baldwin had emailed McClellan asking for the Ricky Davis letters. On February 13th, at 2:41 p.m., McClellan responds as follows, quote, the information that we have concerning Ricky Davis was forwarded to you as part of discovery. You had every opportunity to call Mr. Davis at trial or at the hearing on third-party motive. You chose not to. Your strategy was not to call those people. The trial is now over. Richard Allen was convicted. If you feel you need to file additional motions, then file them. So McClellan himself he told him, McClellan said, if you feel you need to file additional motions, then file them. Now, folks, what does this actually mean? Look at this part here. The information that we have concerning Ricky Davis was forwarded to you as part of discovery. This is a red herring. The defense had information about Ricky Davis talking. They had zero information about the letters. It's a clear difference because it's more information in those letters that could be used. Having cops relaying information. Yeah. Buy again. But please, create a 5th account. Here's the thing. I don't care how long you claim to have followed my channels. I know most people who have followed me from the start. I recognize the names. I recognize a lot. If you do this just to troll, it doesn't matter if I know you. It doesn't matter if you have been a big contributor. Do this fuckery, you're out. It's very, very easy. Don't be an asshole. I try to not be an asshole. I know I can be an asshole, but I try not to. But when you actively go out of your way to be an asshole, don't come here. So yeah, this part here was forwarded as part of discovery. It probably was. They brought it up. The limited information they had through what the prosecution chose to give the defense. This is something the prosecution said, but not this. But not this. Because McClellan claims, oh, it's not exculpatory. It is. It is. And this, if you feel you need to file additional motions, then file them. So McClellan forced the defense hand to file about this. And in filings, you have to bring in the details. Thank you, Jersey Jan. Yeah, F the trolls. Thank you so much. Before filing any motions, Attorney Bolly made one more attempt to simply obtain the letters. The defense responded at 3:54 p.m. on February 13th, 2025, by asking McClellan whether he was admitting or denying that he, McClellan, had received letters from Ricky Davis in the months leading up to the 2024 trials. McClellan could have quickly answered the question and then provided the letters to the defense and perhaps avoided any more filings. McClellan also could have asked Baldwin to hold off on filing anything while he gathered the letters to turn them over to the defense. Instead, McClellan chose to ignore the defense's request, prompting the defense to file its February 14th, 2025 motion to preserve and produce the Ricky Davis letters. It should be noted that the defense was seemingly up against a deadline of sorts. If the defense waited to file the motion, the judge might rule on the motion to correct errors beforehand, which arguably would prevent the defense the ability to file the motion to preserve and produce, as such a ruling would arguably kick the case to the appellate lawyers. Also note that in his February 13th email response, McClellan claimed to have provided the defense all the Ricky Davis letters during discovery. This, well, not exactly, but that is the implication of what McClellan said. This was simply an untrue and misleading statement typed on his computer and sent to the defense by McClellan. Through his February 28th, 2025 filing, the court learned that McClellan actually was in possession of those letters on February 13th, 2025, which contradicted McClellan's representation to the defense that everything had been turned over. McClellan chose to intentionally mislead the defense counsel about his possession of those letters. Yeah, as he says, it's not up to him to decide what is exculpatory. McClellan was getting called out by the defense once again. And once again, he was ultimately forced to turn over the letters, perhaps out of fear that the defense would eventually gather DOC records that would then expose McClellan's misrepresentation. McLelland's misrepresentation has yet to be explained by McLelland to this court or anyone else. Are the letters McLelland finally provided to the defense truly the only letters and or videos in his possession? McLelland's recent response to the defense motion to correct error provides troubling statements that cast doubt on McLelland's claim that these are the only letters or evidence that are in the prosecutor's possession. In the prosecution's response to the defense motion to correct errors, in an apparent attempt to discredit Ricky Davis, McLelland claims that he had information that Ricky Davis had claimed that Ron Logan took batteries out of Libby's phone. This is curious because the prosecution has failed to produce any document or videotape in which Ricky Davis makes such a claim. The defense has found nothing. This leads to serious questions of where did McLelland learn of this information? The defense is left with one of two possibilities. 1. McLelland has additional Ricky Davis letters, reports, or video from where he gained that information. Or 2. For reasons that are unknown, McLelland made up the story. I would go for option 2 here. McLelland made shit up. As Arian says here, the similarities to what's going on in the Karen Reed case are stunning. I wonder if they are cheering each other on. I wouldn't be surprised, but at least in the Karen Reed case, we can see it. Here, Judge Gull is denying, she denied people insight in the proceedings. She denied the public access to the trial. And now, after the trial, she keeps obstructing. And we will come to that later, with the media desperately trying to get the exhibits. It seems unlikely that such a specific story would be made up. Well, leaving the defense to conclude that McLelland has additional Ricky Davis letters, reports, or video, but has not turned it over to the defense. McLelland has not explained to this court, nor anyone else, from where McLelland claims he learned this information about the batteries. Nor did McLelland back up his story about the batteries with an exhibit attached to the filing. Megan Fox in the house. Hey-oh. Oh, we are talking about big fuckery here. And you missed me losing it over a troll by about 10 or 15 minutes. This stream will probably be demonetized. Let's just say that. Sorry. Also, note in that email that McLelland requested Attorney Baldwin to file something, which Baldwin did, only to have McLelland then cast aspersions about the filing. Yeah, you can't tell the defense, if you think I'm a liar, this is not verbatim, this is my translation of McLelland. If you think I'm lying, then file a motion. Okay, we filed a motion. No. Oh, whoopsie. Okay, next part here. McLelland's history of holding on to exculpatory evidence until being forced to or called out by the defense. Unfortunately, as has been the historical pattern of the prosecution, McLelland made a decision to hold on to those letters until called out by the defense, much like he made the decision to hold on to other exculpatory evidence over the course of this case. Again, Indiana Courts of Appeal have commented on patterns of withholding exculpatory evidence and have even reversed convictions when prosecutors have exhibited such patterns. 1. Steve Mullin's claim that the Brad Holder and Patrick Westfall and other crucial early interviews between February 14th, 2017 and February 20th, 2017 were quote-unquote recorded over was not relayed to the defense until January 30th, 2024, in spite of the defense asking for that evidence since August 10th, 2023. As anyone in the criminal justice knows, often the most important interviews are those interviews closest in time to their crime. Brad Holder and Patrick Westfall were on law enforcement's radar screens as suspect very early on in the case. A fact that is evidence from reviewing emails all the way up the chain to Doug Carter in the early days of the investigation. Those emails were admitted as evidence during the July 30th, August 1st, 2024 hearings. Because of law enforcement's very early interest in Brad Holder and Patrick Westfall, each were quickly found, quickly interviewed, within 3 days of the murders. On August 10th, 2023, the defense first unveiled to the prosecution that the defense, believed that the state's own evidence supported that Holder and Westfall were involved in the murders. From a single 2-page document found among hundreds of thousands of documents, the defense found evidence that law enforcement had interviewed Holder and Westfall February 17th, and that both interviews were memorialized through audio or videotape. Now, since then, the prosecution claims no, it was never on video or audio, which is a lie, because there are lying liars who lie. It was after the August 10th, 2023 deposition of Jerry Holman that the defense began demanding those interviews, which the prosecution should have already provided to the defense. Now, with Mr. Holman, hold on here. Let me do my interpretation of Mr. Holman. Hold on here. Hold on here. I'm a mind reader. I'm a mind reader. I interview people and I can read their minds. Yes, believe me, I can read minds. Sorry. Yes, my name is Jerry Holman. I'm a perfect investigator. I might do a mock interview with Mr. Holman. I'm not a crook. Oh. All right, let's continue. When McLeland and Mullin failed to turn over those interviews or explain what had happened to those interviews, the defense called out the prosecution in the Franks memo, footnote 66 on page 56, details that the prosecution had failed to turn over the Holder and Westfall interviews that the defense had been seeking. Even after the Franks memo was filed and the defense alerted the court, calling out the prosecution for not turning over the interviews, the prosecution still refused to answer the very simple question posed by the defense of where is the Holder and Westfall videos? Please turn them over. The defense heard crickets. Instead of immediately alerting the defense on August 10th, 2023, that those videos had been taped over, McLeland and Mullin said nothing. Finally, on January 30th, 2024, the prosecution provided a document that detailed some of the contents of certain hard drives that it had turned over to the defense. In the fine print on page 5 of these documents, the defense finally learned that McLeland and Mullin were claiming happened to those crucial interviews. They were quote-unquote recorded over, along with all other crucial interviews between February 14th, and February 20th of 2017. Neither McLeland nor Mullin called the defense and said, "We should have told you this when you first got on the case, or at least back in August of 2023, but those interviews you have been seeking for the last 5 months were taped over in 2017. Defense counsel has practiced for over 30 years. During that time, if the prosecution in any other county ever received exculpatory evidence or learned that certain evidence had been destroyed, it would immediately contact the defense and tell them on the phone or in person that the evidence had been destroyed. In this case, the defense was lucky to even notice Mullin and McLeland's claim that a crucial video was taped over, as such information was sandwiched between other minutiae contained in a document. This should also not be overlooked. If, in fact, those crucial videotaped interviews were actually taped over, that would be colossal news that Mullin and McLeland would not have forgotten. Losing such evidence would be the talk of the unified command due to the serious nature and potential serious consequence of losing such important evidence. To lose such crucial evidence early on in the case would not be the type of thing that would ever leave the memory of the man in charge of that evidence, Steve Mullins, nor the minds of those in unified command. Therefore, when the defense requested the prosecution to turn over those interviews, Mullin and McLeland should have immediately said to themselves, "Oh no, those interviews were raised back in 2017. I need to immediately tell the defense. I should have told them that when they got on the case, but I will do it now." It is inexplicable that Mullin and McLeland would not have remembered in August 2023, when the defense first requested those interviews, that those interviews had purportedly be quote-unquote recorded over. Now, what's with all of this recorded over? The defense doesn't buy it. I don't buy it. Those were destroyed. We don't know when, because there are no records of it. There are no zero actual records of when those disappeared. My belief is they actually thought we have everything here with Rick Allen. It's an easy case. We drugged him, put him in solitary. He admitted to killing his non-existent grandkids, unfaithful with a matchstick and causing World War III. But in there's also some confessions. That's it. It's an easy case. But then here comes the defense asking weird questions. They start thinking, "Oh, we fucked up. We fucked up." But instead of being honest and saying, "Oh, we fucked up," they destroyed it. Because they had, in their mind, the perfect guy. They only needed to adjust the evidence to fit better. So they destroyed it. That is my opinion. Yet neither McLeland nor Mullin told the defense of this earth-shattering type of news that Mullin had known for 6 years at that time. My apologies. To make matters worse for Mullin and McLeland, when the defense finally learned of the so-called recorded over interviews, the defense asked if there were some documentation, memorialization, Jesus Christ, what exactly happened to those interviews? How it had happened that the crucial evidence had been recorded over. Surely a report existed that would explain this terrible accident that caused crucial evidence to be forever lost. However, no such report had yet been tendered to the defense. Some point in time later, the defense finally received such a report. It was drafted by Steve Mullin. Inexplicably, it was undated. What a coinkydonk. What an absolute coinkydonk. Therefore, no one knows if the report was drafted in 2017 or sometimes in 2024 or anywhere in between. That document was entered as an exhibit at the March 18th, 2024 motion to dismiss. This undated document is not normal, nor the normal way that law enforcement and prosecution operate. I agree. Everything should be dated. The question must be asked, therefore, why did Mullen and McClellan not immediately alert the defense that the Holder and Westfall and many other interviews were recorded over when the defense first asked McClellan and Mullen for those interviews in August of 2023? And why did Mullen and McClellan not turn over the undated document purportedly explaining how the interviews were recorded over until after the defense requested that document? The defense has not seen anything other than an undated document and the words of McClellan and Mullen that support that the interviews were actually recorded over. This is not normal and is very troubling. Neither McClellan nor Mullen, nor anyone else in Unified Command has ever explained to this court, nor anyone else, why they did not immediately alert the defense that crucial evidence sought by the defense had purportedly recorded over. Neither McClellan nor Mullen or anyone else have ever explained to this court, nor anyone else, why it took 5 months before providing a document detailing the claim of Mullen of what happened to those interviews. Those are 5 valuable months during which Richard Allen's counsel could have been investigating the actual claim that those interviews were, quote-unquote, recorded over. This is not normal. Aaron is doing Latin here. Hips dipshit nixus McClellan. Oh, that was so funny. Slider Pie says, like you say here over on YouTube, it's not the prosecutor's job to say it's not exculpatory. Exactly. 2, second example. For over 4 months, McClellan held on to the exculpatory evidence he had in his possession from Todd Click's lawyer, including a certified letter detailing how a law enforcement officer was concerned, essentially, that McClellan may have the wrong man charged based upon evidence that he, Todd Click, and 2 other law enforcement officers had gathered over a lengthy investigation that led them to believe that Holder and Fields and perhaps others were involved in the murders. Yes, that is the so-called FBI task force investigating the Odinist theory. Todd Click, as you know, was charged with bogus things the day before trial, making it virtually impossible to put him on the stand and not be impeached as a crooked cop. The day before trial, Todd Click was charged with bogus stuff. Of the other 2, 1 got murdered by an Odinist, a former correctional officer Odinist. And the third person, I hope you're in hiding, because Jesus Christ. As this court knows from the Franks memo, including documentation provided to the court in that memo, on May 1st, 2023, McClellan received through the United States Postal Service a certified mailing from attorney Paul Brady that detailed that why his client, Todd Click, was concerned that McClellan did not have all the information necessary before making an arrest. This certified mailing not only contained the letter, but also the actual evidence that Click and law enforcement officers Kevin Murphy and Greg Ferenczi is the guy who got murdered, had gathered during their investigation. This included several videos that the prosecution had never turned over to the defense from the likes of Elvis Fields, Rod Abrams, Ned Smith, and Johnny Messer. Again, in a normal world, this would be an earth-shattering mailing to receive if you are a prosecutor. Normally, this mailing would cause a normal prosecutor to immediately contact the defense lawyers by phone to alert them that the prosecution prosecutor had received this information that clearly was exculpatory. However, that did not happen. Instead, the prosecutor held on to the contents of that certified mailing for over 4 months. The prosecutor only turned those documents over to the defense after it became clear that they, the defense, would soon be learning of that certified mailing. In the August 10th, 2023 deposition of Jerry Holman, the defense provided Holman and the prosecution with a 12-page Odin report, where the prosecution had to know that Click was a member of that investigation trio of law enforcement, along with Kevin Murphy and Greg Ferenczi. McClellan had to have understood that it was only a matter of time before the defense would learn from Click himself that he, through his lawyers, had mailed a letter, much like Ricky Davis, to the prosecutor with exculpatory evidence. McClellan's failure to immediately turn over this exculpatory evidence has never been explained to this court or anyone else. Why did it take McClellan over 4 months to turn over this evidence? Similarly, it took McClellan approximately 4 months to turn over the Ricky Davis letters. Delayed discovery of exculpatory evidence without explanation is not normal, but has been a consistent pattern in this case. Number 3. Why in a September 6, 2023 email to the defense did McClellan claim that the Purdue professor's identity was unknown and perhaps would never be known, when in fact law enforcement had known the identity of the Purdue professor since mid-August 2023, if not before that? And why did the defense only learn of the Purdue professor's identity after the Franks memo was filed, calling out the prosecution for absurdly claiming it may not be able to learn his identity? Yeah, this is stupid. Not only did Holman claim that this professor, he couldn't remember his name or anything, but Holman also claimed that this professor supported his theory. Both things were lies. In yet another example of what appears to be an attempt to conceal exculpatory evidence, McClellan has yet to explain to this court or anyone else why he sent an email to the defense on September 6, 2023, claiming that he and law enforcement did not yet know the identity of the Purdue professor, and more curiously, that they may never learn of the Purdue professor's identity. The Franks memo was filed on September 18th, 2023. Coincidentally, the very next day, lo and behold, Jerry Holman actually found and interviewed the missing Purdue professor, Jeffrey Turco. Only 13 days earlier, it was thought that his identity may never be known, according to McClellan. But after the Franks memo, where the missing professor was discussed, he was found almost immediately. Let there be no doubt. The Purdue professor's report and even his October 19th, 2023 interview revealed that murderers may have left behind sticks in the form of runes, consistent with the defense theory. This is called exculpatory evidence. And here is a long footnote. While Turco admitted in his report from 2017 that he could not confirm what the sticks represented, he also said, quote, "The argument that these markings constitute an inscription inspired by Norse runes or modern recreations thereof is quite plausible." These words from Turco were not buried deep in the report, but rather in the very first paragraph. It would not surprising if Holman or McClellan would want the defense to not have access to the report, as the report supported the defense theory that Norse paganists left the sticks behind in the form of runes. Just one thing here. These guys are not believers in the Acer faith. They have massacred and bastardized what they believe is cool. Because in my personal opinion, these guys are diaper Nazis. White supremacy degenerates who just cling on to something because Vikings are cool. Tough people. These garbage beings that claims they are Odinists? No, you're not. No, you're diaper Nazis pretending. You're cosplaying. And before, you would never say that to their face. I went to Delphi. Me and Mo went to Delphi. We walked the trail, and then I stayed behind for hours. Not one had the balls to come up to me. Not one. And then it goes on. Turco's report and interview supported the defense theory that Odinists, Norse paganists were the murderers that left behind ruins at the crime scene. After Holman's September 19th, 2023 interview with Turco, Holman prepared a report dated, because reports are normally dated, September 22nd, 2023, in which Holman admitted that he had known of the likely identity of the Purdue professor since mid-August 2023. If this is the case, again, why did McLean not disclose this information to the defense instead of claiming to the defense on September 6, 2023, that the identity was unknown and may never be known? Again, McLeland has never answered that question to this court or anyone else. To the defense, it appears as yet another example of McLeland's attempt to conceal exculpatory evidence from the defense, much like the Ricky Davis letter. And it is not normal. 4. Why did McLeland fail to turn over the faked crime scene photo found on Holder's Facebook page even to this day? And why did Trooper Roland Purdue twice swear under oath that the faked crime scene image was found on Brad Holder's Facebook page before the murders, only to then change his story on August 1st, 2024 at the hearing on third-party suspect evidence? Yes, folks. Brad Holder's Facebook had the imagery of two girls with sticks over them in similar or identical positions as Abby and Libby. Nobody outside of the immediate investigators knew that. And Brad Holder more or less copied the crime scene. As has been noted in the Franks memo and at various other times, the defense found among the massive amount of evidence a report from Trooper Ryan Winters detailing evidence that suspect Brad Holder had an image on his social media pages that depicted two girls mimicking the very crime scene that law enforcement found on February 14th, 2017. This image depicted two young girls lying on the forest floor with sticks branches on them, with one of the young girls' arms posed almost identically to that of Liberty German. This bizarre image has existed on Brad Holder's Facebook page before the murders, according to Trooper Roland Purdue. Why would Brad Holder, an early suspect, have such eerily similar image on his Facebook page? Unfortunately, the prosecution failed to produce that exculpatory piece of evidence. The defense had to drive to Georgia to obtain that image from the very man, Ryan Boucher, who had located the image on Brad Holder's social media pages. Trooper Purdue, then under oath at his deposition in the fall of 2023, confirmed that the image was in fact on Brad Holder's Facebook page, but that he did not find the image compelling because it has been on Holder's Facebook page for a few years. On July 30th, 2024, Purdue once again confirmed under oath that this early similar fake crime image was found on Holder's Facebook page. Then, very curiously, just 2 days later, Trooper Purdue recanted his two previous sworn statements, now claiming he could not confirm that the image was on Brad Holder's Facebook page. Imagine that. Additionally, Trooper Winters claimed in his deposition that Indiana State Police could not locate the fake crime scene image that at one time was in the possession of the ISP post in Lafayette. To this day, the prosecution has failed to turn over said image. This is not normal. It is also not normal for a seasoned state trooper like Roland Purdue to retract two prior sworn statements during a hearing in which the mimicked crime scene image was a central piece of the defense argument to allow third-party suspect evidence at trial. Yeah. Video of Brad Holder and Westfall in pagan ritual in Fort Wayne. The defense was fortunate enough to locate among hundreds of thousands of documents in a two-page email from Greg Ferenczi to Tony Lidiot, dated December 12, 2018, in which Ferenczi describes a strange video that Brad Holder took of a pagan ritual in Fort Wayne, Indiana. In the video, Brad Holder was taped recording various people in a ceremony, periodically yelling out such things as "Hail Thor," "Oh, you cringe bastards." At the very end of the video, Brad Holder tape recorded Patrick Westfall standing next to a tree and using his hand seemingly mark something on the tree. In the email, Ferenczi commented to Liggett about Patrick Westfall marking the tree with his hand. This is significant because of the F found marked on the tree in one of the victims' blood. Law enforcement had believed that the tree was marked possibly by someone practicing Norse paganism or Odinism. The defense did not get a copy of this exculpatory video. Rather, it had to ask for that video. Eventually, that video was turned over to the defense. It is not normal for the defense to continually have to request to the prosecution to turn over evidence of an exculpatory nature that the prosecution has in its possession. Normally, the prosecution turns over that evidence immediately without any need to request it. This was just yet another example of the state of Indiana holding on to exculpatory evidence before being forced to turn it over. Conclusion and request. What has happened throughout this case is not normal. Prosecutors not turning over exculpatory evidence to the defense is not normal. Prosecutors holding on to exculpatory evidence until being forced to provide it to the defense by complaint from the defense is not normal. Prosecutors claiming they can't locate a key exculpatory witness's identity. A witness, mind you, that purportedly altered the way that the case was investigated is not normal. Later learning that the prosecutor had knowledge of the witness's identity in spite of an email sent to the defense claiming he may never learn of that person's identity is not normal. The prosecution having no explanation for not providing exculpatory evidence to the defense is not normal. Having no explanation why a report that attempted to explain why key evidence is forever lost was not dated is not normal. Having a seasoned law enforcement officer recant two prior sworn statements concerning a key piece of exculpatory evidence that the ISP claims it cannot locate is not normal. Finally, having a prosecutor claim in an email that he provided all the Ricky Davis letters to the defense before trial, when just 14 days later he was forced to admit that he represented as truth in his email was in fact not true. That is not normal. Nor is it normal that one of the letters can't even be located, and that the prosecution has no explanation for this missing Ricky Davis letter. It does not matter whether the contents of those letters can be questioned as unreliable. That is not for the prosecutor to determine. The prosecutor's only determination is to turn that evidence over to the defense. The defense should have had the opportunity to determine the value of that information contained in the letters. It does not matter whether those letters may conflict with other defense theories, as the defense has a constitutional right to possess all exculpatory evidence and then determine how it should proceed strategically in the defense of their client. A local Carroll County rule also requires turning over said evidence. The fact is that the prosecution had in its possession letters in which a key suspect, King Klein, purportedly confessed to the crimes and provided details that only the killer might know. And that information should have been provided to the defense. Because of the prosecution's failure to produce those letters, and because the prosecution has a history and pattern of not turning over exculpatory evidence, Richard Allen deserves another trial. Richard Allen, through his counsel, therefore seeks a hearing in which the prosecutor is requested to explain why he failed to turn over the letters, why he misrepresented his possession of those letters, as well to explain the other examples of failing to turn over exculpatory evidence as resided herein, which show a pattern of such conduct. The defense seeks such a hearing in order to use the state of Indiana's answers to these questions in a renewed motion for a new trial based upon newly discovered evidence, and also in order to use the state of Indiana's answers to those questions as a record that can be utilized by the appellate lawyers, should this court deny Allen his request for a new trial. Lastly, Allen asked this court to order sanctions against the state of Indiana for violating the Carroll County local rule concerning exculpatory evidence. The sanction the defense is seeking is ordering a new trial. This should be a no-brainer. But we all know Judge Gull, crooked Judge Gould, doesn't care. This will probably, unless she surprises everybody and grows conscious, it will be denied without a hearing. She just punts it to the appeals court. And it is infuriating. Derek Crosson, so the FBI knew they had the wrong guy. That FBI task force, which had specialist members, investigated the Odinist theory. And I mean, with everything we have seen in this case, I mean, even Coffin Daffer, and she was on to the Ron Logan thing early on, much earlier than I was. There is 100 times more evidence against Ron Logan than there is against Richard Allen. But Richard Allen is convicted because he was not allowed to bring forward the third-party culprit defense. All right. I got myself thirsty. It took an hour and a half to go through that. And we still have another document to go through. Okay. I have been so busy reading this. Jesus says, all of y'all are probably more Viking than these twat waffles. Yeah. Brad's depiction was not of the crime scene, but it is eerily similar to the crime scene photos. Dun, dun, dun. My father used to call a hammer a friendly persuader. You both. Well, I don't have. Do I have a hammer on there? No, I don't. But I do have. Well, I have this. I'm bringing up to the cottage. This is just a wood cleaver. Well, just. But I have this nice little persuader. So I have that. Mrs. Haunted Parlor, Nick, there are definitely more bombshells coming, apparently with the first sketch released in July 2017. I would not be surprised. All the sketches, all 4 of them, 3 of Bridge Guy and 1 of Guy at Mailboxes, were produced at the same time. Why the investigators chose to only first go out with the generic Indiana man in his 40s picture and not the others, I don't know. And then I don't know why they claimed a year later or a year and a half later that that person on that first sketch is cleared from the investigation. Now we're looking for this guy, and there was the guy in his 20s. Which, yeah, it's so stupid. They should have Kathy Shank to look for the missing audio letter. Oh, Kathy. All of this reeks of absolute corruption. Kathy Shank, I know she sometimes looked through what's been going on in the reporting, and she's not happy we are still on this case, talking about it. Kathy Shank, your daughter was honor bound to Ron Logan, which means you knew. You, Kathy Shank, was the person who cleared Ron Logan. Why? So yeah. Yeah, I see you, Miss Haunted Polar. I see you. I think I know who you're talking about. But it's so unverified, I cannot, because there is so little actual information out about that guy. So I can't go public if it is the same person we both think about. All right, let me just. Oh, by the way, I got myself a treat. I got myself a treat. Huh? Or if I choose to give it away, I have a gift card. No, it's mine. It's all mine. Look at that. That's a beautiful bottle in a tin casing. And just because the troll decided to give somewhere in the region of $20-25 before I booted it, I'm going to pop the cherry here. I need a glass. I need a glass. I have a glass. Yes. Wendy! Hey, Wendy. You have been a member before, so this is renewing, but I will still put it up here as 4 new members of today. Dun, dun, dun. Well, welcome to the Viking crew again. Yeah. Oh, Aberfeldli is world census is not far from when they were born. Slenchi. I need a glass. I need a glass. I have a proper glass here. Oh. Thank you, troll. Well, unless you try to retract the payments you did. You paid for this. Back into the tin. Oh, there. Oh, that's a good one. Not smoky, but still good. Once a Viking, always a Viking. Well, folks, this here is 1,000 years of Scandinavian inbreeding. I've traced my family back to the 13th century. After 12 years sober, I'd still buy an air freshener that smells like whiskey. But thank you so much for your $10 super chat, Wendy. That is very, very appreciated. I appreciate you. I appreciate you. A bit of caramel. Yeah, I can get used to this. All right, folks. Let's get on with the next part. This might be a bit triggery. This is Twist Media LLC's amended motion to intervene and compel access to public trial exhibits. Yes, what we have here, because Judge Gull claimed, oh, you're too vague, you're too vague, you're too vague. So now they went and got really, really specific. Will this help? I don't think so. Judge Gull will refuse this as well, probably. Tariff it. So, Twist Media LLC, by counsel, respectfully hold on, moves to intervene in this action for the sole purpose of seeking access to public trial exhibit following denial of its request by the court reporter of the Allen County. Yeah, the court reporter denied it. It's so stupid. In support, Twist Media states the following. Factual background. Twist is a highly reputed production company and produces programming focusing on news, investigations, and true crime stories. Twist is a media company commissioned by ABC News and is therefore, quote-unquote, media, as the term is defined in Indiana, blah, 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 this. Because Twist is involved in the dissemination of news and is connected with or employed by a recognized press association or wire service and or licensed radio or television station as an editorial or reportorial employee who receives or has received income from legitimate gathering, writing, editing, interpreting, announcing, or broadcasting of news. See Indiana Newspapers, Inc. versus Junior Achievement of Central Indiana from 2012. Yeah. Motion to intervene. Twist Media LLC filed its motion to intervene and to compel access to public trial exhibits on February 7, 2025. Twist Media LLC's motion to intervene and to compel access to public trial exhibits specifically acknowledged that a separate media company had filed a similar motion to intervene and to compel access to public trial exhibits pursuant to the Indiana Public Records Act, seeking copies of public exhibits admitted during the trial in this case. Twist Media LLC's motion to intervene and to compel access to public trial exhibits sought relief similar to the relief requested by NBCU, and under the same legal theory as NBCU, and sought access to similar but not identical public exhibits. On February 18th, 2025, this Honorable Court issued its order or judgment of the court finding that NBCU and Twist Media LLC's request for public trials exhibit were quote-unquote vague and overbroad and do not request with specificity what is being requested, which is bullshit. This Honorable Court conditionally granted NBCU's motion to intervene and to compel access to public trial exhibits, and conditionally granted the general public's motion to intervene and required the submission of specific, particularized requests for the court to consider and accommodate appropriately. Hey, Derek, thank you for your super sticker. It's a gifting of present of sorts. Thank you so much. Thank you so much. Accordingly, Twist Media LLC requests leave to intervene in this action for the limited purpose of seeking access to the public trial exhibits listed below. And footnote says, Twist Media LLC was not present in the courtroom when the exhibits were marked, identified, and offered into evidence. This list provides as much specificity as can be ascertained by Twist Media LLC at this time, including the day of trial, the date offered, the exhibit number were known, the witness offering testimony were known, who created the exhibit were known, and a specific reference to the substance of the exhibit. And this is what was entered on October 18th. Day 1. Drone video. Snapchat photo of the girls in the car and Snapchat photo of Abing crossing MHB, Monon High Bridge. Entered on day 2. Map of the area. Drone footage taken in 2014. Because nothing happens to a wooded area in 7 years. Marked up copy of map from Mullin with locations. Photo of the crime scene from the Weber's side of the creek. Aerial map of Deer Creek, the bridge, and the nearby property of Ron Logan. 9-minute drone video capturing the Delphi trails. Drawing of trail maps by Mullin. Photographs of Libby's shirt and shoe in the muddy water of Deer Creek. Now, why would they ask for all of this? Is it so they can publish all of this? No. It is for them to have access to, include in some kind of reporting, which through ethics blur out things that simply is too much. But they still have the right to view them. They still do. So it's not about being weird. It's not like the troll, the pervert troll earlier. This is for news. What actually went on in that trial. What actually was seen on those evidence. Day 3. Approximately 5 photos of the ground covered in dry leaves, twigs, etc. with a quote-unquote disturbance, as though someone grabbed a rake and cleared all the leaves out of that spot. Photographs of the line of sight of the shirt and shoe from Giancola's perspective. Aerial photographs showing the victims in the woods. Yeah, now we're going into the troubling, a lot of troubling parts here. Aerial photographs of the scene. Aerial photographs of the girls' bodies, a close-up shot of Abby's neck injury, and blood on the ground underneath Libby's foot and leg. Again, I said this might be triggering. If this does bad things with you, I will not blame you for tuning out. I do not. That's definitely not for publication, surely. This is for access. And remember, they can blur things out. And also, the court can choose to seal them, even through appeal. This is just for the reporters. Okay, here's an actual itemized list, which forces Gull to go through all item by item and actually explain why. No, I don't think she will. I don't think Judge Gull will. But folks, there's lots of news reports about crimes, accidents, and stuff. Very few show the actual bodies, the actual blood. If you go on one of these cop shows that show, oh, here's a traffic accident, then you see two blurred things. Yeah, that's the motorcycle driver, and that's his head, blurred out. Digital diagram prepared by Page, showing the location where Libby's and Abby's bodies were found, with topography and landmarks. Photos Page took showing crime scene tape, trees with the girls barely visible in the distance. One of the photos showing the girls' bodies with black marks covering Libby's naked body. Photos Page took from a ladder with the creek in the background and girls' bodies from a higher view. Photo showing blood-stained patterns on a tree on the other side of Abby's body. The essay kits. And here's the thing with the essay kits. It was determined these girls were not SA'd. But so why did they put this into evidence? Well, it's to put it in the mind of the jury that they might have been. That's it. It's emotional evidence. Day 4. Bag containing a black and white Nike size 10 collected. Bag containing a pair of Hollister jeans. Bag containing tie-dye t-shirt. Bag with gray no boundaries hoodie. Pair of underwear. Black and purple sock. Pink sock. Green headscarf. Black faded spaghetti strap. Whatever that is. Collected from, yeah. Converse tennis shoe. Converse tennis shoe. The cartridge. Strand of material. That's the hair in Abby's right hand. Strand of material. Swab from inside of the left wrist. Right wrist. Swab from above belly button. Swab of the thigh above the knee of Libby. Strand of fibrous material from the pinky finger. Swab of a bloodstain on a tree 4 inches above ground level. Black Nike tennis shoe under the body. Swab from blood on the ground between markers 3 and 4. Swab from ground. Swab from ground. Swab from ground. Swab from ground. A lot of swabs here. The iPhone found under Abby's body. More swabs. Black hooded Delphi swim t-shirt, size 2XL. Blue jeans, size XL. Pink sleeveless shirt. Gray cotton underwear. Oh, Carnisol is like a tank top. Thank you. Black bra. Autopsy photos. Google Earth map illustration. Sergeant Brian Bunner's resume. Post-it note for chain of custody with a question mark. Yeah, chain of custody. On a fucking post-it note. PDF of Celebrate logical method report showing latitude and longitude of metadata from LG video. Property record receipt. Photo of LG phone. Case on, case off. Photo of SIM card. Again, more about the photos. Then, screenshot of a man behind Abby. So there's 1, 2, 3, 4, 5 screenshots of man behind Abby. Photo of LG general setting showing EST time zone. The Celebrate map. And here is the big one. The 43-second audio clip enhanced by Chapman. Audio clip. Not video. Audio clip. Now they might mean the 43-second video. But you have been here, you who have been here before, folks, you know that I still say, because throughout the articles and everything that has been reported from what has been reported to media from the investigators, I believe that the audio and the video are from 2 different sources. Jeremy Chapman resume and ISP audiovisual tech Jeremy Chapman, containing the original still frames taken from the video and the finished product after he modified it. I want to see that report just to see what programs did he use to modify it. And here is something really, really, really important. The raw video from Libby's phone on the bridge in its entirety. I believe that 43 seconds is only parts of what was recorded that day. Still frame of interpolated bridge guy. Copies of Bree Wilbur's Snapchat photos. Copy of Betsy Blair's Fitbit data. Still frame from HHS video. Still frame from, this is then showing, Betsy Blair was actually there driving westbound at 2 p.m. or 1:15 p.m. as it says here. Also, still frame from showing Kelsey German's car driving eastbound on 1:49 p.m. A lot of still frames here. Report an affidavit of FBI officer who retrieved video and identified cars. Sarah Carvall marked mud and blood on BG image. Autopsy photos. Again, there are a bunch of autopsy photos. This is not for media. Hey, let's be weird. Let's be creepy. No, it is for the reporting of this case. Blur shit out. Don't think they will ever show it. But copy of Snapchat photo of Abby walking on Monon High Bridge. This was found by Cecil on the internet, not on Libby's phone or on Snapchat. So where the fub did that photo come from? And from what day? Original image of Abbey on Bridge with no timestamp. LG phone timeline from Cecil's extraction. Original knowledge, see database report. Battery levels on phone report. On day 6, more and more HHS videos. And then this photo of Richard's car at CVS, close-up of vehicle in frame. Folks, between 2011 and 2017, there were zero they didn't change Ford Focus for 6 years. No changes. There are literally thousands of them in and around Carroll County. And then items seized in search. Yeah, this is photographs of items in Richard Allen's home. Sealed box with handgun inside. Day 7, surface area images of bullet comparison admitted conditionally. Yeah, I'm still pissed off that anybody can claim that that comparison was done properly. Now, I don't put much into toolmark comparison at all, but when you the base level is compare apples with apples. If it was an unspent, just cycle cartridge, you can only compare it with an unspent cycle cartridge. The fact that this absolute twat went on the stand and told everybody, well, I didn't get good enough marks, so I decided to fire it and then compare it. That in itself should have made everything about that shell casing, that cartridge, inadmissible. This Holman and Richard Allen interview. DNA from Derek Yerman, DNA report. Crime scene photo of the blood. More and more of that. Video of Richard's October 13th, 2023 interview. October 26th interview. RA's request for an interview with the warden. And this I am especially interested in. A binder of Wallace notes for the following dates. Now, her original notes, remember, she shredded. What's in those dates are her cured notes. And we all know about Wallace being a true crime fan, joining in on groups, finding stuff out. Again, anything handled by Walla is questionable at best. At absolute best, it's questionable. Her report. Then you have pictures of Richard Allen at approximately how he looked at the time of the murders. Then you have Brad Weber's 2004 Econoline van. Again, we know Brad Weber. Oh, wait a minute. Brad Weber had a van? Interesting. Zip drive containing audio recordings of conversations between Richard Allen, Janice Allen, and Kathy Allen. Yeah. They only played the things that was, oh, look, he confessed in different ways. They never showed the other things he said while they drugged him and put him in solitary. Brad Health, yeah, his testimony, what he saw. A stitched together prison video. Yeah, because Judge Gold didn't allow the defense to play more than a few. Printout of the objective personality test. NCMI, made of 12 supplemental tests. Thumb drive of video in 5-minute chunks from hundreds of hours of surveillance camera in RA cell to show Richard's life between November 2022 to when he was sent to Wabash Valley Correctional Facility. Yeah. November 2022, later 2023. Yeah. Pages of pings to LG's cell phone. Dr. Martin's notes about his treatment, medication logs, shot logs. Twist seeks intervention for this limited purpose as a surrogate for the public. Wherefore, Twist respectfully requests that the court grant Twist leave to intervene in the above captioned cause for the limited purpose of seeking access to public trial exhibits. Compel the court reporter of Allen County to provide Twist copies of the exhibits covered by the priority request as admitted at trial and not under seal, as at the court's earliest opportunity. Compel the court reporter of Allen County to provide Twist copies of the remainder of the public trial exhibits as admitted at trial and not under seal within a reasonable time from the date of this order and all other just and appropriate relief. Counsel for Twist Media, LLC. Copy of service. Certificate of service. So yeah, but this is all about media. Because for you who don't know, what they are asking for again and again, they should already have. There's no question about it. Media should have access because the trial is over. He is being sentenced. Now it's public records. Now, they can choose to seal some of it, but everything else should be released. And we know that Judge Gull refuses. Absolutely refuses. And it is extremely annoying. Extremely annoying. All right. I have not received any information regarding the guests I have invited. I do know that one can't be on until 1 a.m. my time. That's 2 hours from now. What I might do is that I will set up a new stream. Yeah, I will do that because I will be awake at 1 a.m. my time, which is 7 p.m. that person's time. And then we can just go on and talk about this case. So I will put up a new stream for 7 p.m. Eastern Time. I know very few of you will get the notifications. Will get the notification. But just keep an eye out. But again, these are the newest updates. I asked Andrea, and she said next time, because they have a water leak. They have a water leak at her house, so they are kind of busy. But she said next time, which I will ask. I will ask Andrea every time I do a stream about Delphi. Okay, folks. So I will do that. I will grab a bite to eat, maybe take a short nap. But I will be back here around 7 p.m. Eastern Time. And a person who has still not been on my show will join us. And we will talk about the Delphi case. But that is what I had for you at this point in time. I will send you over to attorney Melanie Little, so you can watch her while you wait for me to return. But folks, thank you. Thank you for allowing me to do this. Thank you to Curative Instruction for being a member, for becoming a member. Thank you to Erin, new member. Salty Sea, new member. The Troll, thank you. Jersey Yen, thank you. Wendy H, new member, thank you. Wendy H for your super chat, thank you. And to Derek Crosson for your super sticker. I will see you back here in an hour and 45 minutes. Bring friends. Bring friends. And until we see each other again in an hour and 45 minutes, have a good one. And remember, folks, hug your family. Unless your family is shit, then screw them and give your love to the people who deserve it. Okay? See ya. Bye-bye.